accountability of arbitrators, increasing confidence of participants. And of course, thank you to all those in the courts who are taking Passovers on your behalf for joining us here. Thank you. While arbitration in India has grown significantly over the years, I think what we're trying to address today in today's panel is, have we actually achieved confidence of the participants, that is the parties, the councils, the investors, especially in the Indian arbitral system? Do we have enough confidence amongst the arbitrators as well as the litigants with infrastructure, resources, capital available to the arbitration ecosystem? What do we improve to present ourselves to the international community as a fast, resilient, and robust arbitration destination? Arbitrators are potentially the most important piece in the arbitration puzzle, and in this session, we hope to delve into how arbitrators can uphold the integrity of the arbitration process and the role that they can play in fostering greater confidence amongst participants. We invite our distinguished speakers to please take seat on the dais. Honorable Justice A.S. Bopanna, former Judge, Supreme Court of India, known for his impeccable sense of integrity, is one of the most sought-after arbitrators and has regularly been appointed as an arbitrator following his retirement from the Honorable Supreme Court in 2024. Apart from being famed for his illustrious career as a counsel, Justice Bopanna is known for his patience and kind smile and ability to put at ease even the most nervous counsel. Thank you, sir, for joining us. Mr. Uday Holla, one of the most illustrious senior advocates of Karnataka, has over 5 decades of experience and has appeared in matters across almost every branch of law. He was designated as a senior advocate by the High Court of Karnataka and holds the unique distinction of having been appointed as the Advocate General of Karnataka on 4 different occasions in 2006, 2007, 2008, and 2018. Despite his busy schedule, Mr. Holla never turns down queries from young lawyers and is always open to mentoring young members of the bar. Thank you so much for joining us, sir. Ms. Pinaz Mehta heads the Bangalore practice of Vadya Gandhi & Co. and has 20 years of experience with the top-tier law firms in India. Her practice areas include litigation, arbitration, and real estate. Her dispute practice is sector agnostic and has ranged from complex construction arbitrations, shareholder disputes, M&A arbitrations, oppression matters, to regular money recovery suits and arbitrations. She regularly appears before the High Court, Commercial Courts, NCLT, and DRT. Thank you, Pinaz, for joining us today. Mr. Narendra Dev is a senior partner of Allied Law Practices and based out of Bangalore. With over 20 years of experience as a litigator, he has represented clients in a variety of disputes, including civil, commercial, intellectual property rights, governmental action, foreign exchange, corporate disputes, insolvency. His practice also encompasses labor and employment, corporate and real estate advisory. Thank you, Narendra, for being here with us today. Mr. Manu Kulkarni, partner of Puvaya & Co., is a distinguished third-generation litigation lawyer with a substantial expertise in arbitration and dispute resolution. He regularly appears before various fora and has a varied practice, including technology and law, to real estate, to regular corporate commercial disputes. Thank you, Manu, for joining us today. I'll hand over to the Honorable Chair.
Very good morning to all of you. Because this program has been going on and am I audible? Yeah. So today's subject with regard to the accountability of arbitrators. Initially, when I saw the invitation itself, I was telling the director of the center, I think this is very unfair. It should have been arbitrators, lawyers, and litigants, and rightly so, Mr. Uday Holla agreed with me. So, to start the discussion with the panelists like this, I think they would be, rather than arbitrator imposing something on himself, the lawyers will tell us how to go about. But however, when now India is becoming a kind of hub of arbitration with centers all around from Delhi to Karnataka, Hyderabad. Everywhere there are centers and arbitrations are going on. Of course, when you say accountability of arbitrators, at best the arbitrator, now there should be something different from competence alone. Accountability is also something like honesty and the way you conduct yourself, the way you make the parties comfortable to come to arbitration rather than continue in the courts. The manner in which arbitrator conducts himself should be the way which would make them comfortable and tell other litigants also that arbitration is a really good alternative dispute resolution mechanism and therefore to choose the same. So in the process of arbitration, if the arbitrator, because I remember when you say accountable, there's a French saying which says, accountability is not for what only you do, accountability is for what you don't do as well. So in arbitration, there are certain things which you should not do, and there are certain things which you should do. And what is expected of an arbitrator, probably in the panel discussion when the senior lawyers and the other lawyers put it across, probably that would be the way. And in the process, it should be not only with regard to the conduct of the proceedings, but also the conduct of not just the arbitrator, the lawyer. And when you say it's an alternate dispute, the manner in which it is conducted should be different from the manner the proceedings are conducted in the court. So with these initial few words, probably I would request Mr. Udayaholla to open the discussion on the subject, and then thereafter we go to the others.
I think I'm audible. Even if I am not, I think even without the mic, I'm audible. I've always said, lawyers must have a loud voice, they may not have a good head. Well, we have today a very interesting discussion. What is it? Accountability of arbitrators in increasing confidence of participants. If we have arbitrators like Justice Bopanna, I'm sure everybody will flock to arbitration rather than going to the courts. Ultimately, the personality of the person who acts as the arbitrator also, brings in a lot of inputs, a lot of confidence level to the arbitrator, to the litigants and the lawyers. It is this aspect which probably must be borne in mind by everybody who act as arbitrators. Ultimately, this is an ADR process. It's an alternative dispute resolution process. Therefore, the arbitrators cannot act just like the courts. They'll have to slightly tweak the entire process in order to ensure that if there could be a settlement, it should be done. And in that regard, I'm sure there should be a change of mindset as far as the arbitrators are concerned. This is one aspect. Second is, as Justice Bopanna rightly said, for arbitration to have confidence amongst the litigants, all the three participants, who are they? One is the arbitrator, other is the lawyer or the advocates who espouse the cause of the litigant, and the third is the litigant. If all the three of them join hands, all the three of them act in the manner that they are expected to, I'm sure ADR arbitration would be a resounding success. Unfortunately, what happens is, some of us lawyers, like me, the moment arbitration starts, we will do what we do in the courts. First, file one application to Section 16. Say this arbitration proceeding is non-est. Arbitrators, this arbitrator has no jurisdiction. This is not maintainable before the arbitration. Once it is dismissed, we will file another couple of applications. So one is there should be a change of mindset even amongst the lawyers who participate in arbitration proceedings. Third, the litigants. I'm sure 70% of the litigants would want the matter to close. Of course, there are always some 3-4 of them, or 20% of them who always want the matters to proceed, go on endlessly. Even there, I'm sure lawyers must counsel their clients, the litigant, that look, it is in your interest to settle the matter, in your interest to ensure that the entire process is hastened up and then closed at the earliest, so that you can go on with your life. So these are the aspects which I'm sure should be borne in mind. As far as the accountability of the arbitrators are concerned, I'm sure every one of us who have joined here as lawyers would choose two things in an arbitrator. One, transparency and honesty and integrity. Second is competence. Only when they coalesce, we will choose that arbitrator. Therefore, one, honesty and integrity is an absolute essentiality. In fact, I remember years back, we had Justice Shiv Shankar Bhatt in a seminar. I had to introduce him, and I told him, I told the audience, he is one of the very honest judge. Immediately got up and said, "What do you mean by this? Every judge is expected to be honest," and that's how it should be. Therefore, accountability would inhere in itself honesty and integrity. One. Secondly, the way they conduct the proceedings. That's why I said in the first instance itself, there must be a change of mindset when you become the arbitrator. It's not just the court proceeding. It is to ensure that the entire process gets hastened up and the litigation comes to an end at the earliest. Of course, in a just manner, not in an unjust manner. These are the things which I think are needed. I don't think I should go on like this. I'm sure there will be so many participants here who would like to ask questions amongst the panelists. And I think I will stop it here so that the others also have more opportunity. Because we have already, I'm sure, the thing that is I still have 5 minutes. I think I'll skip it so that other participants, the younger members of the bar, ultimately I'm the past, these are the present. So I must give them more opportunity. So I'll leave it at this. Any subjects, anything else later if it is needed, I will definitely intervene. Thank you very much.
I think we have got a lot of inputs, and I think this aspect which Mr. Holla mentioned with regard to Section 16 application, that's been my experience thus far. In fact, there are matters where even Order 7, Rule 11 applications are filed in arbitration. And there is no option for the arbitrator, because if you don't decide, that's a misconduct. So you decide the application also. Fortunately, so far, no court has interfered against that order. Maybe there will be instances when Order 16 applications are disposed. Still, they would have filed a petition before the court. Whether it is maintainable or not, that's a different aspect. Sometimes it may get stuck. So these are some aspects which, in fact, the lawyers will also have to advise their clients. That's what I meant when I said accountability is what you don't do also is accountability. Now with this, may I call Mr. You will speak? Or? Yeah. Madam.
Right. Thank you everyone for joining us today. So just continuing on this topic of accountability. When we first started, we thought we'll keep the topic to accountability of arbitrators. And as it's already mentioned, we thought it's extremely important to enlarge this topic, because as I see it, it is an entire ecosystem that we need to create towards the ultimate goal that we have to make India an arbitration hub. And I don't think that it is only the arbitrators which can be saddled with this role. equally important role is played by us as lawyers. Of course, I'm saying lawyers because it is lawyers, us, who advise our clients. While clients, of course, are also a very important part of the process, it is us to steer and guide the clients as to how this arbitration process should take place. So there are lots of things, of course, over here for us to do as lawyers. Few important things are to, tell the client the importance of preparedness, lawyers to come prepared for the hearings, etc., etc. Now, one more aspect that we are talking, I think going to touch upon today is the aspect of delay in passing of awards. Now, again here, the Arbitration Act sets out certain timelines. Now, if the delay, and the main important aspect of arbitration is speedy resolution of disputes. Now, towards this, it is not only the arbitrator who is responsible to ensure that an award is speedily and efficiently passed. It is all us as players in the ecosystem responsible for this. Because the arbitration will start with its pleadings. If the pleadings are delayed, if unnecessarily adjournments are taken at the time of the stage of pleadings, etc., then ultimately the whole process would get delayed. So I think that's where we all play a very important role.
Thanks, Manas. In the first place, very honored to be sitting alongside you, sir, as also Mr. Holder. All of us would agree here that the Arbitration Act, the way it has been legislated, would certainly do with some improvements in the first place. I think the legislation itself would require a whole bunch of changes, which will, in the first place, hasten the process of arbitral proceedings. In the first place, I think the accountability starts with how the legislation is drafted. But we are not here to discuss that particular topic, and therefore I'm not going to delve into that in greater detail. But coming to the specific matter of what Penaz spoke of, which is the delays in the arbitral process. All of us do agree here that there needs to be timelines that need to be put in place. And it is critical that those timelines are adhered to. Oftentimes we notice that it is not just the counsel who are not adhering to timelines, many a times it is also the arbitrators who do not. And as Mr. Holla rightly pointed out during discussions briefly before, it is also the litigants who contribute to this. And therefore, accountability as a process is not just of the arbitrators, but it is also of the counsel as also the litigants. But coming back to the matter of timelines, I will steer in the direction of one particular aspect of timeline, which is Section 29A. We no doubt have the Arbitration Act stipulating that we need to complete the process within a defined timeline. But then again, there is no definiteness to what that timeline is. We have a 12-month period, we have 6 months extension post with the arbitrators, and beyond that you go to the commercial court for your further extensions. But fact of the matter remains that once you go to the commercial court, you do get an extension, and it's the discretion of the court at that time on how much extension is given. And you can, as precedents illustrate, you can repeatedly go back under Section 29A and keep getting your extensions. And so long as the judge believes that you're entitled for that extension, you will receive it. Now, unfortunately, as things stand, the precedents at this point in time merely say that the extension cannot be a matter of mechanical consideration. It has been quite often. And invariably, when we go to court under a 29A process, the court would say, well, it is 29A, why don't we grant extension? Fact of the matter is we need to close this. But then again, in a case where there is genuinely, it's not a case which is deserving of an extension, should the court really be granting one? And for the purpose of completion of the process, let us say that there is one extension that is granted, and the process is still not concluded within the granted timeline. What happens then? Would you still go back? I know the judge has the powers to impose costs, impose restrictions, terms, etc. But shouldn't there be some definitiveness? Because in the absence of that, it's as good as any other litigation going on in courts with no definitive end on the timeline itself. So I believe that from a timeline perspective, if party faith has to be retained in the arbitral process, there needs to be a definitive timeline that also needs to be prescribed under 29A and a definitive process on how one goes ahead and creates specific guidelines on when extensions are granted and when it is not granted. I think that is very critical. And I certainly wish that we have more defining judgments with more granular details fleshed out, which would clarify this particular position. And now I'll pass this on to Manu.
Honorable Justice Bopanna, Harla sir, Honorable Judges of our Honorable High Court, past and present, Honorable Judges of various other courts, past and present, arbitrators, lawyers, friends. Good afternoon, pleasure to be here. When we all saw the topic, we balked, we said, charity must begin at home. So what I did was, I asked myself and I asked a cross-section of lawyers, what are the common errors that we do which we can correct about ourselves, and I begin with a confession, this is something that I also do. So therefore, there's no pointing fingers. I think we bite more than we can chew, and that leads to inefficiency, in the sense that many of us perhaps will never go unprepared, but we are always betting on the fact that we will get some adjournments when we need. In that sense, we always take more arbitration work especially than I think we can reasonably handle. There is always that subconscious part in our mind which says, all right, some timelines are always flexible. I think that's one thing we could avoid. The second is, 16 has come up many times. I wrote 4 words for myself. They are invariably filed, inevitably dismissed, unfortunately without costs or consequences. Now, cost is a tricky business. I just personally believe that we have to have a paradigm shift in terms of how we envision cost. Cost is not necessarily a measure of punishment. It is just another consequence of having taken a point or a plea which was not found favor with. If we look at cost like that and not really as a measure of punishment, then perhaps realistic cost could become a reality. The second bit I thought, where again we almost invariably are, but I think that has come down of late, is we spend a lot of time in, we create a lot of delay in appointments. We want to file objections to Section 11. We want 4 weeks to file wakalat in a Section 11. And then after 4 weeks, when the judge says, do you really want to file objections? We say, all right, appoint an arbitrator. A lot of times this can be avoidable if we can convene on a name. And it is here that some of us need to be a little more stern with our clients to say, nothing doing, I am going to decide along with the other advocate, and please have some faith in us. I don't think we are necessarily that stern. The third, and this I got from a cross-section of lawyers this morning, was sometimes we do more than one arbitration a day or a day. Now, I am not too sure if an arbitration is just like a case in a court, because usually it's paper heavy. So to have more than one arbitration in a day to schedule that way, I think is risky. Time's up.
Generally, no, initially on most of the discussion has been on the timelines in the procedure that is being followed in the arbitrations. Now, I think we may have to advert to certain other aspects also, where probably the kind of procedure that is required to be adopted in the arbitration proceedings, and whether there should be a kind of uniform format for arbitrations where in all arbitrations these are followed, and whether in the process of recording evidence there should be some kind of uniformity in this. So probably if through the experience our senior advocate and the advocates have derived in the arbitration proceedings, if certain suggestions are made with regard to the manner in which this could be adopted, thereafter probably from the House also, if there are some suggestions where these procedures can be adopted, though of course Mr. Dev was talking with regard to certain amendments to the Act and other things. Those are far-fetched things. But at least if these suggestions are put forth and if there is something we can formulate on a uniform kind of procedure with regard to recording of evidence, because now what we see is it's almost as good as a civil suit, the way the evidence is being recorded. And in some arbitration proceedings, they say it should be in the question and answer type, which takes a lot of time, though we have been adopting the narrative form which is being indicated. And in most of the first procedural order which we make in the proceedings, we in fact indicate the procedure for recording evidence also, so that certain things could be curtailed. But then when the actual evidence starts, it becomes difficult because you are again thinking whether if something is disallowed, what happens, are you being unfair to their side, or whether that again becomes a misconduct of the arbitrator for not allowing. There are many things which pass the mind. So there should be a general kind of procedure where at least these are agreed in the institutional arbitration, so that those could thereafter get adopted in the ad hoc proceedings. So if some suggestions on that initially Mr. Holla could touch upon and the others also could suggest, then thereafter maybe other suggestions also can come on this side.
Well, in the court, what we do is, at the time of the cross-examination, every answer that has been given by the witness, we will have to say, this is not correct, this is not correct, this is wrong. So suggestions are put. So one of the things that some of the arbitrators have, especially started with Justice Ravindran, he said, we will have a procedural aspect and a procedural guidelines in the beginning. One of them is, unnecessary suggestions have to be eschewed. You need not, suggest that what you have stated is false. In the cross-examination, you have stated this is wrong. So suggestions to be dispensed with. That will bring down the process of the examination and the timelines with regard to that. Otherwise, there will be some 30, 40 suggestions. And if you don't suggest, in the light of the judgments of the Supreme Court and the Calcutta High Court of 1952, you have accepted what has been stated in the examination in chief or in the cross-examination. So therefore, the dispensing with the suggestions is one aspect which can be put in the beginning itself. Second, the arbitrators keep on giving time. Of course, we lawyers will hammer them and keep on saying, no, today I am busy, next week I have this, thereafter I have this, so therefore post it after 2 months. I think somewhere the accountability of the arbitrator also is that he should be a little stern. It's always as I always say, you must have a velvet glove. It shouldn't be too harsh, but at the same time, that's why I said I gave the illustration of Justice Bopanna here. Whoever has appeared before him will know that, look, he has been very soft, at the same time, stern. So that is what is needed, the accountability of the arbitrators would be, one, that he has to ensure that, the process of arbitration should be hastened up, unlike the courts. Second, that he should, ensure that the process is faster. Third, not give too many adjournments and too long adjournments. Finish it as early as possible. That also is a part of the accountability, is what I feel. Because these are certain things, which I think, are, I'm sure, there are other panelists here who have dealt with it and who have had the experience. I'm sure, the lady here who's had a vast experience of 20 years will be able to throw some light on this.
Thank you, sir. I think on...
Actually, I should have permitted her to speak first because ladies always first.
Thank you, sir. So on the aspect of procedure, one important thing that we miss out, as we were discussing earlier, is the aspect of discovery, which is an extremely undermined tool that is not used in India arbitrations. Now, how does one go about it? Especially when there are documents which are in the possession of third parties, or when there is a case when you need a witness to be compelled to come and appear before an arbitrator. Now, as we all know, an arbitrator is a creature of law. There's a lot of jurisprudence on third parties being a part of arbitration. And there is a provision under the Arbitration Act, which is under Section 27, which deals with court assistance. Now, many a times what I have seen is that we are not effectively using this tool of discovery and interrogatories. One of the things that can be explored is that there are certain soft laws, like the IBA, for example, which is the International Bar Association. The International Bar Association has certain rules on taking evidence, and it clearly sets out the procedural aspects. What can be explored is as a solution when the first hearing happens. Of course, with the consent of the arbitrator and with the consent of both the parties and the litigants, the rules are adopted. Now, those rules can perhaps help in an ad hoc arbitration to streamline the process of taking evidence and how discoveries can be done, how interrogatories can be done. Of course, when we speak of discovery and interrogatories, as far as the institutional arbitration is concerned, their rules are pretty streamlined because they have the processes of how each of these should be carried out. But as far as ad hoc, it might be a good idea to consider adopting these rules such as the IBA. So that is one suggestion that I would like to make.
Manu, do you want to take it first?
On the IBA rules and why perhaps discovery helps accountability, what I have seen is we take outlandish positions in pleading because we know we will not be discovered. And most clients believe that because discovery is not used, a lot of internal communication where they have spoken the candid truth will not come out. Therefore, discovery is a great tool to make sure outlandish positions are weeded out in the beginning. In a suit that is going on as per English law right now in the Abu Dhabi courts, my clients have faced 13 rounds of discovery. Every single discovery application has been ordered so far. And I am not exaggerating, millions of documents have been discovered. So what it does is it prevents us from taking meaningless positions that will never fly, one. And two, it also brings in somewhere the fact that the inconsistency will be on full display. The second that I thought one could do is there is a red fern schedule for discovery. I think it is with the IBA rules. If we adopt that schedule, it just makes the process of discovery that much more easier. And then the real issue and controversy will come to the fore earlier rather than later.
To extend on the matter of discovery, let's take a step back and look at our arbitration clauses in the contract. Now, subject to, of course, rules of certain institutions, it is possible for us that we incorporate well thought out procedural formats into our arbitration clauses. If we are in a position to today say that our arbitration clause will also very clearly stipulate that when a party intends initiating arbitration or responding to one, that that party needs to come to arbitration with all documents on day one. Right? So this is drawing a parallel to how the Commercial Courts Act, of course, today is designed, right? So going back to that, if our arbitration clauses themselves can be drafted in a manner where there is accountability on the parties to submit all their documents and all of their stances or contentions on day one, then we are in fact fast tracking the whole of discovery process as well. And then also to incorporate within that arbitration clause to say that notwithstanding the rules, should a party not have adhered to this particular stipulation in the arbitration clause, that they will be met with certain consequences. And the consequence could even extend to the extent of them not having the opportunity of providing any further documentation in support of their case. So whilst it may sound stringent, but it has the ability and the consequence of hastening processes and also bringing greater accountability not only to the parties but also to the council on how to fast track the process of arbitration and thereby even help the evidence process. And also just to add a bit more on this, whilst it is customary for arbitrators to sit in to take evidence, to record evidence, could we also then look at a system where in many high courts which exercise original jurisdictions, you have that relegated to another officer? So is that an option? And if that is an option, then there is that much more time for the arbitrator that is freed up in order for the arbitrator to concentrate on more meaningful tasks. I'm not saying this is less meaningful, but if there is an opportunity that this can be done by another person, then that also helps fast track the process, because if for any reason an arbitrator is not available or schedule of the arbitrator is full, then the party is necessarily having to wait to undertake and conclude the trial process. So if there's a way that that can be eliminated, that will also have the effect of fast tracking the process. I'll stop at this.
Now, on this process, when discussions were made with regard to the discovery and then the initial order indicating the procedure that is to be followed with regard to the evidence, and then certain other aspects where, as Mr. Manu was pointing out, there would be unnecessary stand being taken by the parties leading to several other litigations. So there was one thought which was crossing the mind of the panelists here, and I think I'll give this first to Mr. Dev with regard to whether the arbitrator should have the power to initiate action for perjury, and whether that would at least bring some sanity in the procedure instead of going haywire. Probably you can start and the others could add.
Maybe I think we should have started with Mr. Holla on this, because he was the one who brought out the perjury aspect also. So the fact of the matter is, in India, we know for a fact that perjury is neither understood by most people, nor is perjury given due effect to by our courts. If you look at perjury in a regular civil proceeding, in a civil court, there is a process that is drawn out. Under the earlier Section 340 CRPC, you would invoke the court's powers and then request the court to initiate necessary actions, make a reference to the magistrate to initiate necessary actions. If you look at the Arbitration Act, we do not have those processes built into it. we do not have any powers for arbitrators that are stipulated within the Arbitration Act on how actions for perjury can be initiated. Whether they could, as a civil court would, could they similarly take on an action for perjury, make an initial determination and directly make a reference to the magistrate on issues of perjury, and of course as to how stringent the consequences are going to be in matters relating to perjury. These are matters because of their absence in the Arbitration Act itself. We probably have to have some guidelines coming from our courts on how this can be achieved, how this can be done, and how the powers of an arbitrator can be expanded and his powers be read into the existing powers within the Arbitration Act. Right. Pass this on to Panas further.
I think one case that comes to my mind regarding this is a recent, I think, Delhi High Court case where the court had held that any misconduct against an arbitrator would be construed as contempt of court. And appropriate, I think there is a provision under subsection 27(5) under the Arbitration Act, which deals on powers of the arbitrator to, as regards contempt of court is concerned. I think that's all I have.
I think perjury, etc., is using a sledgehammer to crack a nut. I don't think it's needed. A realistic regime of costs for a misconceived plea is more than sufficient. I don't think we've even taken baby steps to get there. So therefore, an extreme measure like this may just dissuade people from going to arbitration, because one can, frankly speaking, get away with all sorts of pleas in a court. So why would I go to arbitration? That is one. Two, I think a lot of times when witnesses are given a moment to breathe, they will say things that they shouldn't be saying. Live transcription greatly makes it difficult for witnesses to lie through their teeth, because like Holla sir was saying when we were discussing earlier, somebody coughs, it will record cough. Yes, it creates a lot of difficulty because then there's a lot of gibberish in the deposition, but it prevents somebody to keep thinking and answering. People are compelled to answer. I think those small steps will go a long way. I don't see the need for something like this. Thank you.
If you ask me, why are litigations, unnecessarily prolonged in court of law? Reason is simple. In India, we do not take perjury seriously. If it is taken seriously, half the litigations will come to an end. Take it from me, he who lies the best, succeeds in court of law. That's the attitude that the lawyers have and the litigants have. If Clinton was hauled up, it was not because President of US was not because he lied under, he had misappropriate relationship, but he lied under oath. Therefore, there it is taken up very seriously, perjury, which is not. But then the question now is, should the arbitrators have the power to initiate perjury proceeding? If the courts have the power and nothing is done, can the arbitrators do it? One. Secondly, as Manu was saying, if arbitrators start initiating perjury proceedings, nobody would like to come to the arbitration. One. Secondly, they will start saying that he is already prejudiced, therefore remove him from the arbitrator panel and put somebody else. Therefore, it may be counterproductive if you have this provision inbuilt into this arbitration itself. But then, as was stated by the panelists, if the arbitrators, when frivolous applications are filed, if they impose costs which the person who has lost will have to pay, make it a little higher than the normal cost, I think that will bring in some kind of a sanity, would be my suggestion. Of course, there are various ways of looking at it. I'm sure the arbitrators themselves know how to deal with it. But then these are aspects in which I think are needed, which will also bring in about some kind of a sanity amongst the arbitral proceedings itself. Thank you.
Now, having discussed with regard to these certain timelines, the procedures in the arbitration proceedings, then the natural question that would arise is, of course, last year also that was there and somebody suggested that, but then later there was a strong dissenting voice that it should not be. That the way the proceedings are happening in the arbitrations, this question will definitely arise where the procedural aspects are involved as to whether there should be a devoted bar for arbitration proceedings. In the sense whether, because we also see many a times, of course, no, I don't mean anything against the advocates who have appeared, because I always, whenever they ask for a different date or a different time, I always say lawyers are busy, we are not busy. So doesn't matter, we can give the time. See now, why I say this is, probably the proceedings takes a long time. Many a times when you are fixing the date, if you, as arbitrators, we are there to do a full-time job also. If we say 11 o'clock, naturally the lawyers are busy in the court at 11 o'clock. It's not possible. So it is either afternoon session, evening session. So therefore you will have to adopt to some procedure to suit that also. So in that context, whether a devoted bar for maybe even the regular lawyers who are going there, they'll have a set of lawyers who can only go for arbitration. Whether this is a possibility, probably the lawyers will have to tell us. Because otherwise, many a times this happens, and every time we feel that maybe if somebody had assisted from morning, we could have gone ahead with the matter. Probably, I think we can start with the senior most here, who will give us his view on this.
I entirely agree that if there is a devoted bar for arbitration, matter will hasten up, undoubtedly so. But then, what also happens is, a litigant must have confidence in the lawyer. So he'll choose the lawyer. When he chooses the lawyer, he may choose the lawyer, who's going on with who's devoted to arbitration alone, or who's competent enough to deal with every matter. Ultimately, arbitration process and litigation, there's a parallel. Therefore, this is one aspect. But then, if you ask me personally, a devoted bar for arbitration is a must. Whether it will happen or not, I don't know. Honestly, if you ask me to say that, look, would you devote yourself only to arbitration bar? I will say no, personally. But then, that is my selfishness, not in the interest of arbitration, not in the interest of bringing to an end a litigation or the ADR process. So this is my personal view. Thank you.
I think the necessity of a separate arbitration bar is not only from the lens of, timing or availability of, lawyers on regular days rather than having arbitrations post 7 o'clock or on, Saturdays or Sundays. I think it goes beyond that, because what we also need to do is curate lawyers basis subject matter of disputes, just like how perhaps we also need to have arbitrators who have an understanding or deeper understanding of the subject matter of the particular dispute that is before them. Now, generally, in my experience, what I've seen is, although we have, panel of, 3 arbitrators, we end up having 3 lawyers who are, acting as arbitrators. But sometimes the nuances of a particular dispute requires us to think of or curate people who are not only lawyers, but also have a certain subject matter expertise. For example, if there is a real estate dispute, and the real estate dispute entails typically construction of delay in timelines or disputes between a developer and a landowner, it requires certain expertise in that field of law or in that field. So just like how the arbitrators we need to expand that and perhaps look beyond just lawyers as arbitrators, uh, we also need to expand this pool of lawyers to, have, younger members of the bar or just practicing advocates to be appointed or nominated as arbitrators, because they could perhaps, lend the subject matter expertise that they would have in a particular field of law. So that's my...
Thanks. This is a slightly tricky issue for us to be speaking of, as Mr. Holder rightly pointed out. Deeply conflicted also to be addressing this particular issue. So here are a few thoughts on this. In the first place, are we suggesting that a set of lawyers only practice arbitration matters and not really do anything else? We have a variety of subjects that are litigated in courts. Are we today suggesting that we clip the wings of a set of lawyers and force them only into an arbitration bar and not allow them to do anything else? Second, it's also an existential question for many people, for particularly young lawyers who may not have a very thriving practice, would need to be in courts, but also have arbitration appointments. Are we then suggesting that by denuding court-going lawyers that opportunity, we are still being an inclusive bar, an inclusive community of lawyers, by actually excluding economic viability for a whole set of people? To me, that's a very existential question on the practice of law itself. One has to draw a fine balance the way I see it. It is desirable only from an expediency perspective that we have an arbitral bar. I do not know if others agree, but to my mind, I do not see any other significant, tangible benefits emanating from an exclusive arbitral bar. On the contrary, if we've had lawyers who've practiced across multiple areas of law and are able to bring those areas of expertise to an arbitral process, wouldn't the arbitral process be a whole lot more holistic? I would believe so. As I said, this is a bit of a tricky issue, and I don't think there could be definitive answers in this matter. I'll pass this on to Manu from here.
I think I more or less fully disagree with my dear friend Narendra Dev on this. I think it is quite well known that different lawyers practice in different fora, different areas of law. For example, I don't think neither I or Narendra Dev would ever do a regular criminal trial, not because we don't want to do it, but at least speaking for myself, I think client will get better justice from somebody else. Therefore, I won't venture to do it. Now, that kind of specialization, expertise, by whatever name called, is there in multiple areas of law. There is no reason why it shouldn't happen on the arbitration side. One. Two, in the morning session, when I was listening to senior advocate Mr. Singh, he was mentioning how construction law has its own nuances. Now, candidly, the only nuance I know about that law is, I know there is a great book called Keating on Construction. I have used it a few times. But there were terms that he was using in the morning that I was unaware of. Terms that he was saying are well known in jurisprudence across the world. Now, until one picks up and reads or pores through a book like that, I will not know. To the extent I have used it, I know. So therefore, developing expertise is I think going to be the way forward, and it's better for everybody in the system. And two, I think it's also essential because it's a question of time management. I think it's a real issue. There are many of us here who have requested specifically, like Justice Bopanna was saying, for arbitrations in the afternoon, in the evening. So I think it's a reality. Now the question is, what do we do? I think it's for us to make a choice. Like Holla sir was saying, we have got to make a choice. Really, I think that's the solution, but there is a crying need.
With this, I think we have generally discussed whatever we felt was important on this subject, which was to be discussed. So at the outset, I thank Mr. Udayola, Madam Pinaz, Mr. Narendra Dev and Mr. Manu Kulkarni for their input. And as we said, of course, though we have, maybe we are left with a minute or so. If on these aspects what we have discussed, if there's any better suggestions from the audience here, probably that also can be taken note and then we can conclude.
I think we have a few minutes. This panel has not caused any delay, as we can see, has been very efficient. So we can take some questions.
So thank you very much. I want to start with Kulkarni sir. Yes, can you hear me?
Madam, you can sit down and
Yeah.
because arbitrations are done.
Okay. Okay. So I agree with Kulkarni sir, and I really agree to disagree with him. The first thing is about the delay that we had talked about, and it is already, we all have witnessed that why the delays are there in arbitration. Most of the time it is seen that we go to the arbitration center and one of the party, he or she, writes directly an email. This is what is witnessed recently, that recently they have sent the emails to the arbitration center and it is not marked to all of us. So we go from that big distance and we go there and then the arbitrator gives us a date. So this kind of incidents have happened very regularly, and I think all the arbitrators will agree with this. So that can be covered in case if there is a penalty clause, which is under the law, that in case if this kind of a thing is happened, then the arbitrator has is bound to put the kind of a penalty. And then everybody knows that this is going to be they are going to pay that. So that is one aspect. Then another aspect is about the, exclusive bar, which again I disagree. Simple reason, because it is like a super specialty. Yes, when we started our career 35 years back, we all know that there was no super specialty, but it was only criminal and civil. Whereas now, we can see that there is a super specialty even in our field. And I think in coming years, it will naturally happen. So whether we like it or no, I think yes, we will have a class of and great number of advocates who are going to be practicing in this field itself, and they will not even prefer to come to the court. So that will happen in a natural course, I feel. Thank you.
So you said you disagree, we thought we should not have.
I think
Sir, if I may just add to this, do we want to read exclusive as exclusion? That was my only question.
Not really. I just think it's somebody predominantly doing something. So I agree. agree with madam.
Sorry, I'm going to abuse the power of having the mic to ask my question. I think my questions to Mr. Holla, if I can, was if there is, we don't always all know all the arbitrators that are being appointed. So to increase the accountability of arbitrators, is there anything the institution can do? Because not always do the parties know the arbitrators.
If I may just add, sir, I had a question. It was my turn, please.
Yeah.
So I have this question for the panel. See, forgive me, the question is slightly longish. Arbitration, as we all understand, is essentially an arbitrator is appointed by virtue of a contract between parties. So, sorry, arbitrator is a creature of a contract when two parties come together. Very often this contract is not written. Not very often, almost never written, except that we have an appointment order. The terms of appointment are never inscribed in any place. But I think everyone here will agree that there are certain implied terms. I just listed out a few of them. One, that he will apply the law, that he will consider every contention that's advanced before the arbitrator, that he will discharge his office honestly, fairly, competently. This, of course, is there in a way in the statute also, that he is required, he'll devote the required amount of time for the task at hand. He will not imperil the parties by abandoning his office, that he will not demand higher fees than after the commencement of the course, and that he will respect the time the parties, and that he will ensure timelines. He will devote the required amount of time to the task at hand. I think most people here will agree that these are basic things that we expect from an arbitration. And therefore, I would say that these are implied terms in a contract. Now, sir, coming to my question. Now, there may be implied terms, there may be express terms. We could have a situation where the agreement with the arbitrator is a written contract. Now, if there is a breach of it, if there's a breach of any of these things, is there a contractual liability as far as the arbitrator is concerned? When we talk about accountability, now, is the arbitrator liable under contract? Let us say, is he liable for cost of arbitration, loss suffered by the person, or is there any other consequence, like maybe preventing the arbitrator from disbarring him from taking up any other further arbitrations? Are these kind of issues of accountability? How would you respond to this?
See, as far as accountability is concerned, all those aspects in which you just now narrated, being a part, which should be part of the contract, if the arbitrator breaches any one of them, it actually amounts to misconduct. So it need not be mentioned, would be my submission. It is inherent. When you take an arbitration proceeding, he has to be honest, is implied. He has to do the job in a professional manner, is implied. That he shall not charge more fees than what was agreed is implied. So therefore, there is no need to put it in a particular format. One. Second, as far as accountability is concerned, whether he should be saddled with some cost. Now my answer would be, it would be counterproductive. No arbitrator would like to take up the matter, because you can make accusations against him. It's like a judge. Is a judge accountable? Answer is yes. Accountable to whom? Accountable to the higher judiciary. Accountable to his own conscience. So if you say that, look, if he finds, we find that he has misconducted, we will saddle him with cost, then nobody would like to be an arbitrator. It may be counterproductive, would be my submission. Anyway, it's as I said, there are always no two lawyers agree, no two doctors agree. Therefore, there's always another view to it. But personally, it would be counterproductive, would be my submission. And secondly, today, at least in our High Court, and generally everywhere, it's the judges, retired judges, and who are appointed as arbitrators. And they, by their own volition, by their own training, by their being judges for a long time, all these are inherent in them, would be my submission.
I have something to add. I think it is interesting that we are talking about accountability in the context of not honesty, dishonesty, but in the context of efficiency and inefficiency. That's a dimension to accountability, specifically in the context of arbitration. Recently, when a Singapore law firm partner came down and I had the occasion to meet him, he said now the Singapore arbitration tribunals have started asking for the witness statement along with the claim statement. They said you better know your evidence before you file the claim. So here we have the practice of shooting the bullet first and then looking for the evidence. There he said, if you, for instance, want to lead expert evidence later, you may rather have the expert evidence today. Appoint an expert on your behalf, of course. Appoint an expert, get the expert statement and file it along with your claim statement, or file it along with your witness statement, which should come with your claim statement. Because you know your evidence before you file the case. I think that's something that India can start thinking about. How it is feasible to a large extent, I wouldn't be able to say, but I think that's a direction that we can start thinking about. But I think since we are also talking about accountability of the larger fraternity and not merely arbitrators, that's what we started with. I think we should really tell our clients that expectations will have to vary across the different kinds of arbitrations. If I'm selling a 30-40 site, I enter into an agreement to sell, but I instead sell it to somebody else, and damages is what is sought in an arbitration. It need not take 12 months. But today, India is facing very large infrastructure arbitrations. It's very, very difficult. Like Mr. Holla said, two lawyers don't agree. Even if you have two chartered accountants, they don't agree. They are dealing with figures, but they don't agree. Valuation issues, people don't agree. Technical issues, people don't agree. And therefore, it's very, very difficult for judges to finish, or arbitrators to finish, or lawyers to understand the matter. It's very easy to say you learn the subject and do the matter. It's very, very tough to learn a new subject and for one matter and to finish it in time. So I think we should also, I'm not dismissing the whole discussion which has happened till now, but I think we should also distinguish between matters and lay down the expectations very clearly that smaller matters can be finished off, evidence, etc. can be finished off. Maybe the tribunal can lay down a pattern right in the beginning that on certain issues, evidence will not be entertained. On admitted issues, on admitted documents, evidence will not be entertained. Only on disputed documents, evidence will be entertained. That and all can be laid down in day one. But I think in heavy infrastructure matters, we should make it realistic in front of our client that we cannot possibly finish it off. And I think that goes a long way in ensuring accountability.
I just have one.
May I add something to this? I'm sorry, go on.
Sorry, I'm just going to piggyback because it's connected. Just 3 suggestions, and mainly coming from things that have worked. One, in select cases maybe, along with the procedural order, if the scope of dispute is seemingly narrow, is there a chance of saying the parties, if they all agree, will also submit a statement of admitted facts? This has worked in the DIFC courts, which they're very efficiently used. Second, on the regime of costs, if there can be public knowledge of what costs a party is looking at, if let's say there's a frivolous section 16, and in the, Manu mentioned the Abu Dhabi courts, they have enforced this system of security of costs, where a person is not able to make a statement. And so these 2 aspects, and of course, there was some discussion on discovery, and we've seen it work as a double-edged sword in 2 different ends of the world. In the US, now they've started selling arbitration as, look, it is freedom from discovery, because in the US, discovery is sold as a bad word. We have not taken our first step there. So, and since discovery is a time-intensive and a cost-intensive process, are there some rules that institutions can come up with to say this is the scope of discovery and this is how it will work?
If I may, sir. So I fully agree with what Prashant had to say. But in addition, I'm just going back to a pre-arbitration process. I'm certain that good many lawyers here have drafted arbitration clauses in their contracts. All of us have done it at one point of time or the other. But if I were to ask for an honest answer as to how many of you really checked with your clients if they wanted to arbitrate on a particular dispute, can you say that you first consulted with your clients and then incorporated an arbitration clause? How many of you can say that I did consult? Right? Very few hands is what I see. Right. So going back to the issue of party autonomy, in the first place, what we have noticed in most cases, including in very high-stake matters, parties have seldom understood that there was an arbitration clause getting incorporated, what it would entail, and are they really up for an arbitral process, or would they much rather be in courts? So according to me, this is a fundamental duty for a lawyer to inform their clients. And once that information trickles down to the client and then they ask questions, then they are fully informed of what it entails, is when all of these other matters can get fleshed out within the contract itself to say, how do we then make this a more efficient process? So I would urge everybody, all the lawyers who draft arbitration contracts, to first educate their clients on what an arbitration clause is, how it impacts them, what are different kinds of disputes that may arise under a contract. Some disputes could be small, some very large. And would we want to even arbitrate on small ones or restrict only arbitration to larger ones? These are matters that I think lawyers have a duty to inform their clients. And I think lawyers also have a duty to think a little more thoroughly about how they want to articulate many of the procedural mandates within the arbitration clause and get the buy-in from the other side on how they want to really arbitrate an issue should a dispute arise in future. And I think that is very critical. And if this is addressed at the threshold, a lot of these discussions will then become very academic.
Thank you so much for the discussion. Thank you so much for the discussion. My question is to Mr. Manu. I agree, sir. I agree 100% that the most ignored regime is the cost regime, right? In 50s, 60s, 70s, most of our judgments would have an order as to costs. Two-part question. Why is it being ignored in today's practice? And what steps concretely can stakeholders take? Because I have been at discussions where costs are brought up, but we've not been able to move to concrete action with any of the stakeholders in the systems to create a disincentive structure for litigants, arbitrators, lawyers, etc., to actually put it in practice.
I think I'll answer this after Justice Bopanna does. Sir, cost I think you should say. Why you're not imposed?
Yes. This aspect, of course, see, one we are looking at making arbitration popular. At the same time, we are talking about certain strict rules to be applied to arbitration, including punitive costs. See, unless this procedure of punitive costs, as is being imposed in other countries, for which people don't take unnecessary or unwanted stand before the authority. If that is not there in the courts, and if you are imposing it only in arbitration, people would stop coming for arbitration and still prefer courts. So it can't be a one-way traffic. It will have to be, the entire process will have to stand. The courts also will have to be so strict, the manner of imposing costs, punitive costs, should be there in the courts, and in this alternative dispute resolution also that should be followed. But otherwise, if you are only saying that costs should be imposed by the arbitrators when stand is taken, people would still prefer not having an arbitration clause when they know proceedings before the arbitrator is stricter than the court, and they're bound to lose something if they don't. So normally, of course, the arbitration clause is agreed at the beginning, and as Mr. Narendra Dev pointed out, it's not explained so much in detail, the arbitration clause. But now, as of now, you would have already seen that in some government contracts, they've already passed an order that they will not have arbitration clause. For whatever reason they have done, that's a different thing. So here, if these punitive actions are thought of only in arbitration proceedings, in my view, probably, and let us say now what Mr. Manu had said also, as an arbitrator, if I have to explain, if tomorrow I think I'll be strict and I'll start imposing cost, Nobody will agree on Bopanna as an arbitrator in the next matter.
He'll still agree, sir.
Arbitrator. No, what I am saying is myself. So nobody, I mean, you can't be that, and as Madam was pointing out, the adjournments being sought by sending emails, that is happening in ad hoc also. See, now it's easier to say certain things that you will not do it. See, now supposing somebody is asking you for an adjournment over email with a reason. Unlike in a court proceedings where they are before you, you say, no, in 2 weeks, I'll give you only 1 week, or make a face, and then they would say no. This doesn't happen there. And if you, for 4 weeks, if you say 2 weeks, and then again there's another request, how do you see it? That's the reason we initially started with saying it's not just the arbitrator, it is the lawyers and the litigants as well. Because they should know, once they have opted for an alternative dispute, they should also stick to this alternative dispute to make it more efficient. So therefore, in that circumstance, I would say that punitive costs may not be a solution at this point. And now, Manu.
Sir, if I may just add, sir, what I think is that we have to reimagine costs. We have to have a paradigm shift. I don't think costs are necessarily a measure of punishment. They are simply a way of saying one side who brought a claim lost, and therefore as a measure of full recompense to the party who is successful for having been dragged to court, your entire expenses are given back. So if we imagine costs that way, certainly not as a measure of punishment, but as a measure of full recompensation to the winning party for having been dragged through the process, then I think perhaps one means, as a lawyer, as a client, one becomes more accepting of the cost and says, okay, if I lose, I'm going to lose the case, I'm going to lose lawyer's fees, and I'm going to pay for the lawyer's fees of the other side. If we look at it that way, I think the costs regime will become easier to implement.
We have time for just one last question, please.
Good afternoon to the chair and the panel. I only want to understand the opinion of the panel. If the panel thinks that there's a need for a special institution to be set up by the state to oversee the arbitration, and also to possibly offer some kind of a certification or something which the arbitrators has to go through, so that they have some special skills, maybe at the foundational level, to discharge their duties more effectively.
One thing that we must always remember, arbitration is an ADR process, alternative dispute resolution process. Let's not have all the cumbersome processes, rigors that you find in the courts. Then they will not come here. See, the whole attitude, there should be a paradigm shift in the attitude itself, in the mental makeup. There should be a change of mindset. Ultimately, this is to ensure that, there is access to justice at the earliest, and in the most, not in a regimented form that you have in the courts, but in a manner where, clients feel comfortable, litigants feel comfortable to come, discuss, see if there could be a settlement. Now, all that is not possible in the courts because it is totally regimented. Therefore, with that in mind, if you bear that in mind, I think, many of these, things get answered automatically.
Thank you so much, everyone. May I request Mr. Sriranga to please come on stage to felicitate our speakers. Thank you, Justice Bopanna, for joining us today. Thank you, Mr. Holla. Thank you, Manu. Thanks, Pinaz. Thank you, Mr. Narendra. Thank you for this lovely session. May we give one last round of applause to our panelists here. We will now break for lunch. Our lunch will be served on the first floor. We'll gather here again at 3 p.m. for the sessions. There'll be 2 parallel sessions happening in lecture hall number 1, which is also on the ground floor, and here. Please join us for both. Thank you.